Hello, everyone, and colleagues, friends, students. And my name is Lucina Ho. It is a distinct privilege for the Faculty of Law to host this book launch for Jordan English of Magdalen College, Oxford, who is currently visiting us as DVC visiting fellow. Now, this launch is especially timely because the book has just won the prestigious Peter Burke's Prize for Outstanding Early Career Scholarship. And we're also very privileged to be joined by a very distinguished panel of discussants. We have, I'll start with this gentleman closest to me, my colleague, David Winterton, Professor Lin Siyi from Chinese University of Hong Kong, and Professor Alex Look from the City University of Hong Kong. They're all experts on contracts and unjust enrichment in Hong Kong. Now, I won't repeat Jordan's remarkable achievements, which are already stated in the bio in the flyer, but a little due diligence reveals a history of exceptional achievements that haven't been included in that bio. For example, he has received the Distinguished Young Alumni Award from the University of Queensland and was a university medalist in law, graduating second in his cohort, despite taking 4 extra courses in his final year. So those of you who are doing overloading, no excuse for not being the top students in your class. Now, he did this overloading in order to finish the degree ahead of the schedule to work as an associate of as an associate to Justice James Edelman. He then went to Oxford as a Monash and Rhodes Scholar, which set the stage for the outstanding work that we are celebrating tonight. So we're all incredibly eager to hear about the book from him directly. Please join me in giving Jordan a very warm welcome.
Thank you very much to all the discussants for coming here and taking time out of their day, to Lucina, to Rebecca, and to Grace for organizing this event, to the HKU Center for Private Law, and to obviously HKU in general for actually letting me be here today. And of course, thank you to all of you who took time out of your semi-busy schedules, for some of you, looking at my students, to come here. So my job today is essentially, you would think my job was just to write the book, but no, I've been given one more, which is to provide an overview of the book and then try and also provide an overview, and I won't provide any comments on my own work, but an overview of chapters 2 and 3 of the book, which I think in some ways really set the scene for the chapters that follow and that the other discussants are going to be talking about. So to start with the overview, the core claim this book makes is simple. It is that discharge following breach, discharge in cases of frustration, and discharge in cases of common mistake can each be explained as instances of the discharge for the failure of a condition. And by condition here, I mean an uncertain fact or event which qualifies an obligation to perform. To put the claim another way, the reason why one or both parties are discharged from their obligations to perform in such cases is that their obligations were expressly or implicitly conditional on the existence of particular facts or the occurrence of particular events, which either do not exist or in the events that have happened have not occurred. Now, if I were making this claim 100 years ago, this would not be controversial. I would probably go so far as to say this claim would be trite. But today in England and other common law jurisdictions, such as I dare to say Hong Kong and Australia, few subscribe to this view. Instead, what you're taught in contract law courses is that we have a doctrine of termination for breach, we have a doctrine of frustration, and we have a doctrine of common mistake, none of which depends upon the conditional nature of our obligations to perform. Indeed, so entrenched is this view that Professor Burrows, as Lord Burrows was then known, once wrote that it would be misleading to draw too close a link between these different doctrines. So the result is that we have 3 seemingly disparate doctrines, all in want of a justification and each giving rise to their own difficult doctrinal problems. So the best way to illustrate the central claim in this book, I think, is with an example. So suppose that on 1 January C contracts with D for the use of a music hall for a week at the end of the month and promises to pay £100 for that privilege. Then consider the following three scenarios. On 10 January, D burns the music hall down, scenario 1. Scenario 2, on 10 January, the music hall is struck by lightning and burns down. And then scenario 3, on 1 January, an hour before the contract is signed, the music hall is struck by lightning and burns down. Now, according to modern orthodoxy, English law has three different doctrines to deal with these particular problems. In the first scenario, we would say that C is given a power to terminate on the basis that D has either breached a condition, by which we mean an essential term, any breach of which gives rise to a power to terminate, or on the basis that D has breached a nominate term, the effect of which is to deprive C of substantially the whole benefit that it was intended they should obtain under the contract, deprive them of the bargain. So then in the second scenario, where the music hall was struck by lightning and burned down, we would then say, well, this is now a case of frustration, and the parties have been discharged by the doctrine of frustration. And in the third scenario, where, if you recall, an hour before the contract's entered into it struck by lightning, we would say the contract is void for common mistake. Yet the model that I want to put forward, and the model that I do put forward in the book, is to say that the reason that C is discharged in each of these examples is the exact same. C only promised to pay for the music hall if they got substantially the whole benefit it was intended they should obtain from the bargain. In other words, if they got what they bargained for, the use of the music hall, their promise was then conditional upon getting the use of the music hall. So in the first scenario, where D burned it down, the condition did fail due to a breach of duty by D. But the only relevance of that breach of duty is that it gives C a claim for damages. C is still discharged because of the failure of the relevant condition. I only promise to perform if I get the music hall. In the second and third scenarios, this condition failed, but this time without any breach of duty at all. And this reveals an important point, that promises and conditions are distinct. You can breach duties, you can breach promises, but you cannot breach conditions. But notice that in this example, where it's not due to any fault of D, C is still discharged due to the failure of the condition. And that's because C didn't get what they bargained for. But notice how D is not going to be discharged for the same reason in the case where it burns down due to no fault of their own. They are only going to be discharged if they expressly accepted such events from their obligation to perform. They said, I'll only promise to perform if the music hall still exists, or because their obligation was implicitly conditional upon it being possible for them to perform. Then if we come to look at the second and third scenarios, so you recall where it's struck by lightning on 10 January versus where it's struck by lightning an hour before the contract's entered into, the only difference between these two scenarios is in terms of the timing. If the obligations of the parties are conditional, then whether the contract never imposes any obligations upon the parties, i.e. the doctrine of common mistake, or whether it does impose some obligations upon the parties, but some or all of these obligations are subsequently discharged, is simply a matter of when the fact ceases to exist or when the event fails to occur. In other words, when the condition has failed. And the short point is that each of these things are not distinct doctrines, but are each instances of the failure of a relevant condition. Unfortunately, modern orthodoxy can't see that and instead treats these as three completely separate doctrines. So in the time that I have left, I want to focus on chapters 2 and 3, which, as I said, sort of set up part of this claim in relation to breach cases. So that is cases involving discharge following an actual breach of contract, but will in a way, I think, set the scene for some of the chapters that follow. So to summarize the claim that's being made in those two chapters, there are two things that are considered orthodoxy in English law, I hope. The first is that following certain kinds of breaches, the innocent party is given a power to terminate. Exercising this power discharges both parties from their obligations to perform, but unless and until that power is exercised, the innocent party remains obliged to perform under the contract. And the second proposition that is considered orthodox in English law today is that there is a distinction between two senses of the word condition, even when used in its promissory sense. So a condition can mean, on the one hand, an essential term, the breach of which gives rise to a power to terminate. Or it can also mean some uncertain factor event which qualifies an obligation to perform, so a condition precedent, a concurrent condition, or a condition subsequent. So what chapters 2 and 3 aim to do is show how historically there was no distinction between these two different concepts. But through a series of missteps and loose language, English law came to inadvertently recognize this distinction. Now, unfortunately, I can't run you through the arguments that I make across about 100 pages in the book, but let me give you an overview of the barest essentials. So at one point in English history, questions of one party exercising a power to terminate simply just did not arise. In a case where one party was faced with non-performance by the other, the question was whether or not the mutual obligations or their mutual promises were independent or dependent. If two promises were independent, then that meant that one party could sue for the non-performance of the other without having to show and without having to prove performance of his or her own promise. In other words, the two obligations were unconditional. By contrast, where two promises were dependent, then a party suing the other for non-performance had to show and plead and prove performance of their own promise, or at the very least that they were ready, willing, and able to perform. And this is because the obligations of each party were conditional upon performance, or at least conditional upon being ready, willing, and able to perform by the other party. And if the party had failed to fulfill the relevant condition, this simply meant that the other party's obligation just had not fallen due, and therefore they were not in breach and they were discharged from their obligation. So you can hopefully see in this rough sketch how on this model and this historical model, questions of termination simply didn't arise. Moreover, when the word condition was being used in these old cases, it wasn't being used in the modern sense of an essential term, the breach of which gives rise to a power to terminate. Instead, it was being used in the sense of a condition precedent, concurrent condition, condition subsequent, an uncertain factor event which qualifies some obligation to perform under a contract. However, as sometimes happens with the common law, things get lost, things get confused, and things get muddled together. So there were, in essence, 3 steps which led English lawyers coming to see conditions, not as meaning that something was conditional, but rather as meaning an important term, the breach of which gives rise to a power to terminate. So the first occurred in 1852, which essentially occurred as a result of a change to pleading rules, which was not intended to have this effect. So as a result of these changes in 1852, it became possible for a defendant, for a plaintiff to allege generally when bringing a claim that they had complied with all their conditions precedent. And it then became for the defendant to specify the condition of the plaintiff's obligation that he or she was alleging had not been fulfilled. And this led to a change in emphasis, whereas previously the plaintiff had to say, I have complied with conditions X, Y, and Z of the defendant's obligation. They could now say, I've complied with the conditions present to their obligation, and the defendant had to specify which stipulation, the performance of which was a condition of their obligation, that they were alleging had not been performed. So the emphasis changed from saying, I've complied with the conditions to you have failed to perform this relevant condition. And that, combined with loose language, led judges and barristers and lawyers to start talking about parties breaching conditions. But if you recall what I said a little bit earlier, logically speaking, a condition, if it's an uncertain factor event qualifying an obligation, can't be breached. It either occurs or it doesn't. What can be breached are obligations, promises to bring conditions about. The second shift was that there were some cases, particularly the Court of Appeal decision in Benson and Taylor, which suggested that if I, as the innocent party, am faced with the non-compliance by the other party with a relevant condition, but I allow them to go on and keep performing, I might be held to have waived the condition and so still be under an obligation to perform. Because the idea was that, well, if you wanted to waive this, if you wanted to rely upon the non-performance, you ought in practice to say something. And so this led to this practical advice, which was that if you wish to ensure your discharge, you ought practically to tell the other party that you're intending to rely upon the non-fulfillment of the condition to ensure that you're not found to have waived it. But this very practical advice about how to negate an inference of waiver came to be seen again with time as an essential legal step that you must take in order to bring about a discharge of your contractual obligations. The proposition being you need to take steps in order to terminate. And then thirdly and finally, there was a case called Hayman and Darwin's in the House of Lords where various law lords in the House of Lords made statements to the effect that when dealing with an anticipatory breach, which David's going to talk about a little bit later, that when dealing with a breach which has not yet occurred, it has no effect unless and until you accept the renunciation by the other party. Now, that is orthodox, but of course, that's talking about things that are not yet actual breaches. And unfortunately, we use the language of repudiation, which is what they used in that case, to also refer to actual breaches. And so what began to happen is people applied these statements about needing to accept the repudiation to cases of actual breach, saying you need to accept the other party's breach. In other words, you need to terminate in order to be discharged your obligations. So those are the three steps. Now, in the brief time I have left, I want to just quickly say, so what? Why does any of this matter? Right? It could be this is all very, very interesting, but has no practical relevance. Well, the short answer I want to give you is that it does have practical relevance. So I'm going to try and highlight just two of those things, and then say something about how we can move forward. So the first is that we've got these two different models that now coexist, the power to terminate model and what we might call the failure of condition model. And the difficulty with the power to terminate model is it gives conflicting answers to quite simple questions. So take this one. Can I terminate for my counterparty's serious breach of contract if I myself am in serious breach at the same time? Now, the power to terminate model has given conflicting answers to this question. One decision, Gallaudet, says clearly yes. Another decision of the House of Lords, Bremer-Vulcan, says clearly no. Well, on the failure of condition model that I'm suggesting here, the answer is clear. If A, let's use party A and B, if A has breached a promise, the performance of which is a condition precedent to B's obligation to perform, or A's non-performance has deprived B of substantially the whole benefit of the bargain, then B's subsequent conduct in not performing is not a breach. Equally, if A's non-performance breaches a term, the performance of which is a concurrent condition of B's obligation, then neither party is in breach while the other is not performing. A second example, which I can do quite quickly, because I have a minute left, has to do with how promissory warranties work in insurance contracts. So promissory warranties have always been understood to work in the exact same way as promissory conditions, i.e. terms that give rise to a power to terminate. So what happens if a insured breaches a promissory warranty, but before the insurer cancels the contract, before the insurer terminates the contract, an insurable event occurs? If we take the power to terminate model seriously, the answer should be the innocent party, here the insurer, remains bound to perform unless and until the power to terminate is exercised, which means if an insurable event occurs before they've terminated, they must pay out. Well, the House of Lords in a case called the Good Luck said no, the insurer is discharged from the moment that the breach of warranty has occurred. And again, that looks very difficult to explain on the power to terminate model. So I said to say something about going forward, and I'll finish with this. These two models coexist. At one point in time, I might have suggested that we completely turn back the clock and get rid of the power to terminate. But to do that, we need to get rid of about 50 years of authorities. And I just don't think any court, I don't think any court is going to be bold enough to do that. So what can we do? Well, the fact that we were asking for hundreds of years whether or not one party's obligation was conditional is significant. And there are some cases that I discuss in the book which show that not enough emphasis is being given to a question which we should be always asking before we get to the termination question, which is, was this party's obligation to perform conditional? And if we put more emphasis on that question, often questions about termination, the importance of those would completely retire from view. So that's all I'll say.
Thank you, Jordan, for giving us such a succinct summary of the main arguments of quite a number of pages in the book. Of course, if you want to read the real thing, you should definitely go by it. And I'll say a bit more about that later. From now on, the discussions in the summaries of the books will be just as succinct but a little bit more critical. So let's start with David, who will be dealing with chapters 4 and 5, as well as 8. Thank you.
Well, thank you very much, Lucina. Jordan, esteemed colleagues, and the many students who are here today, which is great to see. It's with great pleasure that I join you in order to offer some remarks on Jordan's excellent recent and prize-winning monograph, Discharge of Contractual Obligations. As one of the few Australian academics that is a serious doctrinal contract scholar, as well as just an all-round good bloke, Jordan is both a well-respected colleague of mine and has increasingly become a good friend. It's accordingly a genuine honour for me to be here to contribute to tonight's event. So since I've been designated as first cab off the rank amongst the discussants, I thought I'd just make a few very general introductory observations about the book before moving on to my substantive remarks. So first of all, I'd like to record just how brilliantly written I think the book is and how clear it is. So I recommend it to all students as an exemplar of how to do legal writing, and also as an exemplar on the subject matter itself. And this is particularly impressive given the complexity of the subject matter, which, as we're all three of us are going to discuss, and as you've already seen from Jordan's remarks, is truly the case. Given the history of this area and the difficulties, it's extremely impressive what Jordan's been able to achieve. Secondly, I'd like to record my comments or views that I think the thesis is essentially correct, and I have very little by way of critical commentary, although I'm going to try and pick up a few minor points and sort of draw attention to some of the more important implications. I think the book's argument is both highly persuasive and compulsory reading for anyone interested in the subject matter. And I've actually long held a sort of something like the progenitor of this view, although I certainly wouldn't say that it's as well developed, or I could have put it as clearly or persuasively as Jordan has. But having read many of the cases and articles that he discusses in the book, I've long thought that failure of condition is a better explanation for much of the law. And I also note one important thing that might help you see just how sort of correct the basic thesis is that it explains why we use the word condition to explain or to denote an essential term that gives the other party a power to terminate, which is otherwise quite perplexing. And I've always found difficult to explain to my students, other than by using this model, why we use the word condition to describe an obligation. And the reason is because, for the reasons that Jordan's explained, of this historical confusion as to the role of conditions in this context. Finally, I actually would like to say that I think Jordan perhaps undersells just how important the book's central claims are. As he noted at the end of his remarks, he says, well, it's all well and good. I've given you a good account of the history, but perhaps it's too late to move on. And how much does it really matter? Well, as he pointed out, it does matter in a couple of important ways. And I'm going to draw attention to a few other ways in which I think it matters. But I suppose perhaps because I'm more of a theoretical purist than Jordan is, I think that in and of itself, the fact that he's given us a true account that unifies various disparate doctrines, irrespective of whether it actually affects concrete decisions, although it does, is in and of itself a very valuable contribution. And so I'd just like to point that out. Okay, so as I said, moving on to my substantive remarks, I'm going to focus on chapters 4, 5, and 8, which concern waiver of conditions and the doctrine of anticipatory breach. And I'm also going to draw attention to a couple of notable Australian cases that Jordan mentions in the book, but given his focus is English law, perhaps doesn't discuss in the amount of depth that he would have if he was writing for an Australian audience. Okay, recall Jordan's central thesis. In all the instances where a contracting party is discharged from the obligation to perform their remaining contractual obligations, despite not yet having completed their own performance, for example, frustration, common mistake, or the other party's sufficiently serious breach or repudiation, the reason why that party is discharged is because there has been a failure of a condition upon which their obligation to perform depended, right? And that's a concept that unifies these various distinct and disparate doctrines. A corollary of this primary claim is that whenever there is an express or in Jordan's words, implicit as opposed to implied condition, which is something we might pick up on in questions, upon which one party's obligation to perform one or more contractual obligations depends, the party will be discharged from the obligation to perform unless that condition has been waived. So to make this a little simpler for particularly, I suppose, the students amongst us, one objection that someone might raise to Jordan's thesis is, well, there are situations where there has been a failure of condition and the party is not discharged. So how do you explain those? And I think the central answer that Jordan gives is, well, all those cases, at least the ones that are correctly decided, can be explained on the basis that the party, the innocent party, has waived the need to comply with the condition. And, you know, as I'm going to go on to say, the doctrine of waiver in the law of contract is one of the most notoriously difficult and not well understood aspects of the law. And I think Jordan's book does a remarkable and impressive job of shedding light on this most difficult topic, which has generated debate for many years. And I imagine will continue to do so, although clarity is definitely being improved on account of this book. So Jordan discusses 4 distinct circumstances in which conditions can be waived. And this occupies chapters 4 and 5 of the book. Chapter 4 focuses on the waiver of conditions by election and the waiver of conditions by estoppel, both of which I think any student who studied contract law would be relatively familiar. And then chapter 5 examines waiver of conditions by prevention of fulfillment and the particularly difficult and misunderstood topic of waiver of conditions on repudiation. Those 2 forms of waiver, I think, are ideas that will be less well understood by at least the students in the room, although I may happily be wrong, but this is getting quite advanced. So I'm going to focus on chapter 5, but just before I do, I just want to say 1 or 2 brief things about chapter 4. If I had more time, I would do chapter 4 more. I would do it in more depth, but I just don't have the time. So as I said, given constraints, I don't have that much time to speak about chapter 4, which is waiver of conditions by election and estoppel, but I'll just make a couple of points. So the first is that I agree with Jordan's important claims that there has been an over-reliance on the concept of estoppel. And something that I think most students realize when they're going through is that the prevalence of estoppel, particularly if you study in Australia, which has a very expanded notion of promissory estoppel, it sort of has come to dominate much of this area of the law. And Jordan, one of the great features of Jordan's book is that I think he puts estoppel in its proper place. It clearly has a role to play, but it's just one amongst a number of doctrines that are relevant to this area. And some prominent Australian authorities, particularly Fawn and White, which is the one case I'm going to discuss in a bit of detail in a few moments, is a good example of the confusion that can arise if we try and make estoppel do too much work. Okay. A second comment I'd like to make about this chapter is that it concerns the question of whether there is an independent doctrine of waiver, in the sense that, so to give a little bit of background, years ago, someone by the name of Ewart wrote a famous book entitled Waiver Distributed, in which he argued that the doctrine of waiver, which is a term used in many different senses in the law of contract at least, can be distributed into a number of various doctrines. And once you do this, the doctrine of waiver is essentially vanishes, and there's no independent doctrine of waiver, right? So the doctrines that he discussed and that I had in mind when one makes a claim of this kind are election, right? So waiver by election, waiver by estoppel, waiver by variation, i.e. variation of a contract, which would require new consideration. Obviously, waiver by estoppel would require detrimental reliance of some kind and a representation. Waiver by election requires a choice between 2 mutually inconsistent courses of action. And then potentially, and more controversially, there are some other doctrines like forbearance, which might be necessary to explain some cases that can't be explained in others. And perhaps this is something we can also pick up on in questions if there's time. So the key issue is there an independent doctrine of waiver, which is necessary to explain certain cases that can't be explained by any of these other doctrines? And fortunately, this issue arose recently in the High Court of Australia in a case called Allianz Australia Insurance and Delavue apartments that has sadly gone, I think, a little bit without substantive commentary. And, you know, it's an important case, if not only because it raises this question, but also because there was an interesting split between Chief Justice Gageler, who's a very well-respected judge and the current Chief Justice of the court, in the minority by himself, and the majority, which comprised the rest of the court, notably including Justice Edelman. Now, while Chief Justice Gageler held that there is an independent doctrine of waiver in Australian contract law, presumably justified by reference to the desirability of finality in commercial dealings. So, put another way, the value that exists in not allowing a party to blow hot and cold and mess another party around, even if the other party can't show that they've detrimentally relied upon a representation that's made by the other party, right? So the point is, often if you mislead a party, they will detrimentally rely, and so they'll have some estoppel argument. But this independent doctrine of waiver, and on the facts of Delavue itself, there was no detrimental reliance that could be proven. And so the question was, could the party that had waived, in the loose sense of the term, or given up their right, were they precluded from going back on abandoning or giving up their right, even though the other party couldn't show that there was detrimental reliance? And I think, and this is again something I'd be interested Jordan to comment on if he has time, I think that the best justification for this, if there is one, has to be the interest in finality in commercial dealings and not allowing a party to blow hot and cold. And whether that's a convincing justification is, I think, something that reasonable people may disagree on, which is perhaps the reason why we have this disagreement between Chief Justice Gageler on the one hand and then the rest of the court on the other, who said, no, who pretty much said that there is no independent doctrine of waiver, or at least were very skeptical as to its existence. Okay, conscious of time running out, so I'm going to now move on to chapter 5, which is, I think, the most difficult, perhaps, topic in that Jordan considers in the book. I'm not going to get a chance to talk about damages at the end, I think, which is unfortunate. But I left it to the end because that's my pet topic and it's kind of my baby. But I'll leave it for another time. So the second, so in chapter 5, Jordan deals with waiver of conditions by prevention and waiver of conditions upon a repudiation and the doctrine of anticipatory breach. Now, just very quickly, the first half of the chapter, which is waiver of conditions by prevention, deals with the fiction of fulfillment, and Jordan persuasively argues that English law, to the extent that it has done, was wrong to adopt the fiction of fulfillment and that it should be abandoned, which I think is consistent with this very recent Court of Appeal decision, King Crude, which I understand is also going on appeal to the Supreme Court. So this is a very relevant topical issue, something for people who may want to write a thesis to write about potentially. And then in the second half of the chapter, he deals with this question of waiver of conditions upon a repudiation and the doctrine of anticipatory breach. So now the doctrine of anticipatory breach, I think, is a doctrine that nicely sort of could be said to exemplar that familiar aphorism. Sure, that idea works well in practice, but does it work in theory? And I think this, the doctrine of anticipatory breach is a good example of this phenomenon in action. So what Jordan does, I think, a very good job of doing is explaining how, even though the modern doctrine is said to arise with the well-known decision of Hoxter and de la Tour, it's actually in the version that he understands based on this failure of condition model, as opposed to the power to terminate model, the doctrine is much older. And this point was well recognised by the late great Sir Owen Dixon in the Australian High Court decision of Peter Turnbull and Munda Strading, where he said, now, long before the doctrine of anticipatory breach of contract was developed, it was always the law that if a contracting party prevented the fulfilment by the opposite party to the contract of a condition precedent, therein expressed or implied, that was equal to performance thereof of the condition, at least for certain purposes. Put another way, it may be said that a positive absolute refusal by one party to carry out the contract, or his conduct in incapacitating himself from performing his promise, obligation, dispenses the other party from the useless formality of tendering performance of that condition. So the basis of this so-called dispensation principle is that the law will not force one to do a useless or nugatory act. And as I mentioned, this really was the principle that operated in Peter Turnbull and Mundus Trading, but also in the more recent High Court case of Foreign and White, which, given I'm very close to running out of time, I won't go into the facts of, but what I will say is it's actually an example of a case that very much fits the fact pattern that Jordan mentioned in discussing the first reason why this distinction matters, as because it was a situation where at least arguably both parties were in breach, but because they were in breach, actually they weren't in breach of a concurrent and mutually dependent obligation, it meant that actually neither party was in breach. And so the court's analysis, which focused on, well, could either party breach even though the other was in breach, and was there an estoppel that arose in this context, was all really unnecessary and by the by, when they could have quite simply resolved the case by reference to the fact that there'd be a failure of condition that discharged both parties from performing, and applying restitution for failure of condition would have allowed the purchaser to obtain the deposit, which was what they were seeking in the action. And so the point is that the case could have been resolved much more simply on the failure of condition model, but the courts got themselves into a mess because they adopt the power to terminate model, and shows very, very well why Jordan's analysis is so illuminating and can simplify what is otherwise a very overly complex area of law. Thank you very much.
Thank you. This is brilliant, and thank you for keeping time. We're now moving on to the next two very important chapters on mistaken frustration that Alex will introduce to us. Thank you, Alex.
Thank you. I agree with David that this is a beautifully written book. When I teach my students, when they write essays, I say you need to have a strong narrative structure. And I typically hold up Harry Potter Volume 1 as an example of a strong narrative. Now I've got another example in legal language of what good writing is about. So thank you very much, Jordan, for giving this book and for me to have another example to show to my students. Now, I would say that it is so beautifully written that it comes close and maybe even exceeds Peter Burke's. It is an introduction to the law of restitution. And it shares another attribute that Peter Burke has, which is that it is so persuasive that you want to swallow the entire thing, hook, line, and sinker. And when I use the word hook, line, and sinker, then it shows you that there are some dangers that you might want to avoid. And the danger which I want to advise you on is actually this. If you use this book and solid hook, line, and sinker, and bring it before the Court of Appeal in Hong Kong or the CFA in Hong Kong, you're going to have a bit of a hard time in a number of areas. And so today, perhaps my job is to give you a little bit of overview of what the chapter on frustration is about, but also I see as my role as a commentator to also highlight some areas which I think you might find some difficulty with if you go to court using these arguments. In other words, this might be my critique. Now, so what's the nature, therefore, of the argument in the chapter on frustration, which is chapter 6, I believe? As you have heard, the book really is to say that that implied condition is actually a common factor, and it explains explain what this common condition is about. And it becomes, therefore, shall we say, the overarching theme and explanation for a number of doctrines there are. And this extends, therefore, to the doctrine of frustration. Allow me then to read from page 177 of the book. Parties are discharged from further performance of their contractual obligations because the parties have agreed that the obligations are conditional upon the existence of particular facts or occurrences of particular events. The non-existence or non-occurrence of such events discharges parties from the obligations. This is actually quite uncontroversial, and you will think back to the case of Taylor and Cowell, the grandpapa of frustration, if you wish. So you remember the case, the facts of which are that there was a music hall, which you talked about earlier on, and the music hall burned down. Right? And importantly, the plaintiff here was actually the renter of the music hall, which sued the venue provider for not providing the music hall. So the question was whether there was a breach of contract such that damages were payable. And the court held that because the subject matter had been destroyed, therefore the obligation had also fallen away, and therefore there was no obligation and hence no liability in damages. So far it's all very consistent, right? So from there, you remember that Taylor and Kong was about implied term, right? So that nicely supports Jordan's thesis. But as we know, the law has also since moved away from implied terms as the theoretical foundation of frustration. The test we use today is that found in Davis and Ferrum. Let me just state that. Whether there is a radical change in the nature of the obligations by reason of the change in circumstances so that the parties can say, this is not what I promised. I'm paraphrasing here, right? So if I'm correct, then what Jordan is saying is that we should confine ourselves, therefore, to the implied condition, and this subsequent development essentially is superfluous. Right? He doesn't quite say that in the chapter, but that's my interpretation. So my initial reaction to the chapter was, why is Jordan trying to revive this theory or this implied terms theory of frustration, which has been repudiated and is repudiated by a number of cases, right? But as I read further, I found that he was doing more, right? He's saying that frustration is essentially about interpretation, it's about construction, and in other words, when he talks about implied condition, he's saying that construction is all you need in order to find out whether the condition or the obligation has fallen away. So that is why there's not quite a need, I think, for this further test that we often cite for frustration. I wouldn't go into this now, but perhaps you can clarify a little bit later on. So, the more important thing is actually this. This is my take home for myself after reading the chapter. Why it is useful and why it matters is actually this. Because it's a condition, and the condition can be waived, that also posits that it doesn't mean that there's automatic discharge, right? I think that's an important thing to bear in mind. So it's a bit more nuanced as a proposition and gives you a more nuanced answer, not automatic discharge, but it can be waived, but it can also continue, right? Now, so that's, I think, that for me is a take-home lesson for why it does matter and it can work, right? I'm not saying it cannot work, it can work. But I have a few problems swallowing this line sinker. In order to be persuaded by this thesis, we need first to jump through a number of barriers. One of these barriers is what is implied terms about. And those of you who have done contract law will know that there's this case called AG of Belize and Belize Telecoms, where Lord Hoffman says that implied terms is basically about interpretation. Okay, right? And Jordan actually agrees with Lord Hoffman. But we also know that the Supreme Court, in a later case known as Marks and Spencer, restored the orthodoxy, and which is that we should not conflate implied terms and interpretation. Not that they're not related, but we use different doctrinal handles or pathways by which we argue for implied terms, and we have a different method that's involved when we are dealing with construction, right? And so that's Marks and Spencer, which has been affirmed in Hong Kong in the 2023 case of Hong Kong Polytechnic University against Rehabed Society. So that's therefore the law in UK, the law in Hong Kong. I would also then say the law in Singapore. And so we can't run away from the fact that this orthodoxy has been restored, right? And so then how do we get to, given that that is the law, how do we get from how do we get to saying that implied condition through these doctrinal handles to the fact arguing in court and succeeding in court? Now, so my second header is how does to discuss how does contractual construction or interpretation function under the prevailing theory of frustration. It is not a foreign notion. It is not a foreign notion. For those of you who are familiar with the doctrine of frustration, we don't jump into frustration without considering what the contract is about. And in fact, if you look at Davis and Ferrum, it says that you need to have a true construction of the terms which are in the contract read in the light of the nature of the contract and of the relevant surrounding circumstances in which the contract was made. In other words, we need to have a proper holistic construction of the terms of the contract. And this is said by Lord Reed. Now, this is important to bear in mind before we come to Radcliffe's test that I cited to you earlier on, where he says that frustration occurs whenever the law recognizes that without default of either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render a thing radically different from that which was undertaken by the contract. In other words, this is not what I promised to do. So frustration, therefore, is very much about the construction of the contract. Now, in other words, before we come to deciding whether frustration operates, we need to go through a very extensive investigation into what the contract is about, what the bargain is about, as well as what the obligations are between the parties. Now, the difference between Davis and Ferrum, and shall we say the orthodoxy, and Jordan's approach really is this. It comes down to, again, a Lord Hofmann against a majority in the UK, which is actually this, right? You see what you have here as a very contractarian model. Everything is about the contract and what the parties have provided for, even if it's objectively interpreted. As contrasted to frustration being also about a rule of law. Okay, that's where the fight. That's where the fight is about. This therefore echoes the other fight which Lord Hofmann had with the majority in the UK, which was, remember, assumption of responsibility under Hadley and Baxendale, whether there's this new category. In Lord Hofmann's assumption of responsibility, there's a very, very deep contractarian kind of notion underneath that. Okay, whereas the majority with the more orthodox view still sees it as shall we say, a kind of more rule of law kind of approach, right? So I think that's the difference, therefore, in the theory, and this locates Jordan, therefore, in the Lord Hofmann's camp, shall we say? And you can say that's not true when you reply to me afterwards. Okay. Now, then you will see the other strand that comes up very strongly in the chapter is he places a lot of emphasis on the objective theory of contract, which is that he says that the contract interpretation is not about what the parties are actually thinking, but what is laid out there. Okay, the analogy that you use from Snoopy and from Charlie Brown is this: is your speech bubble which counts, it's not your thought bubble that counts. Okay, so that's the way I see it. Okay. Now, but in line with many Oxonians, and that includes Lucina, I would say perhaps sometimes it goes a bit too far because it's like everything is about objective theory of contract. Is there no relevance for the subjective elements, right? And I would argue that there is sometimes the subjective elements are actually important. So think, for example, about unilateral mistake, not common mistake, which is common in this book. It is an excuse, it is operative if one party subjectively is mistaken, right? And I know that you're mistaken, all right? In order to establish that defense, you must prove that I subjectively know that you are mistaken. That's that's the relevance of subjective theory, all right? Not that it is an overriding theory, but it has a role to play when we are dealing with excuses or when we're dealing with vitiating factors, okay? Now, how about implied terms then? In implied terms also, you have the role for subjective thinking. So think of implied terms. I just said that objective theory means that we look at a speech bubble and not the thought bubble. But there can be a place for the thought bubble. And that's where you have implied terms in fact. Implied terms, in fact, is about something which is so obvious that it goes without saying. You thought about it in your head, and A equals A in your head. That's why when the officious bystander comes to you and says, is this term blah, blah, blah in the contract? Both of you turn around and say, of course, has to be, right? Because that is something you thought about, it's assumed by both parties, right? In other words, therefore, there is a small role for subjectivity, although it is not an overriding theory, okay? Now, as we know, when we deal with implied terms, apart from implied terms in law, there's also implied terms, implied terms in fact, there's also implied terms in law. And this is one part that I think if you're included in your chapter, it will be even stronger if you bolster your case. Because implied terms in law does not depend on your thought bubble. It depends on necessity, and the courts have said that this comes from, shall we say, common law policy. Common law policy. I think that's an important facet to bear in mind. It must be consistent with the party's intent, but it need not stem and proceed from the party's intent. And I think that's an important point to bear in mind because this is therefore the law in operation, instilling its values into your contract. Okay? Now, so when it comes to implied terms, as you can see, there are tests and not easy tests in order to satisfy, in order to get to your result. And sometimes these tests are not going to work so easily. Just 1 minute more. Okay. Okay. So so what I want to say is there is a cut short to this. Okay. There is a place for risk allocation by the law in frustration. In other words, apart from the parties allocating a risk amongst themselves, the law comes in when the parties have not allocated. All right, you can call it construction if you wish, because it's objective theory. But I think it is actually somewhat more candid, perhaps more honest, to say that this is the law allocating that risk, all right? And that's why we use Davis and Ferrum. Let's myself to stop. That's why we have Davis and Ferrum, which tells you that there's something more than merely the parties' agreement, because this is where the law steps in to allocate the risk somewhat, given the nature of this contract. And in that sense, therefore, there is a certain marching in line with implied terms in law because it's necessary for that type of contract, except that in implied terms in law, you must identify a clear category of contracts. In frustration, you don't need that because it may be peculiar to the facts. Okay, thank you.
Thank you. This is perfect. Now we have seen to talk about chapter 9 on unjust enrichment.
Hello, everyone, and thanks, Lucina, for arranging the event. And it's really my pleasure to be here, have the chance to join the discussion about Jordan's new book on discharge of contractual obligations. So I'm asked to discuss chapter 9 of the book. For chapter 9, is a little bit different from the previous chapters that we just discussed, because it's about how Jordan's model has an implication beyond the law of contract and on the law of restitution. So for you guys who are probably not so familiar with the law of restitution, it's about whether and how to return those benefits that you received, either it's because there's something unjust or it's because you don't have a legal basis, a reason to hold it. So to briefly recap, Jordan's model is about how failure of condition can be used to explain discharge of obligations following breach, frustration, and common mistake. And when I first look at the term failure of condition, as I used to research a lot on unjust enrichment, I thought it's something in relation to the failure of condition as an unjust factor when we discuss unjust enrichment. And then when I jumped to chapter 9, I found, oh, there is, of course, a relation, right? But it has different meanings in different contexts. And I echo both Davey and Alex's view that I feel the book is written in a very beautiful way. And I also find it's very useful, not only for contract law courses, but also explain a lot of, I feel, difficult questions for me that I found difficult to explain to my students in the unjust enrichment course. And this is about the implications Jordan summarized about his model on the law of restitution. There are 3 implications to briefly summarize. The first one is about how this model can be used to explain what is conditional in the failure of condition when we discuss this as an unjust factor in the law of restitution. And when I first read this question, I feel a little bit like surprised because when I first start to learn the law of unjust enrichment, I find it's a very important unjust factor, but I never ask what is conditional when we look at failure of condition, because I feel it's kind of like self-evident. When I read the Fabrosa case, even more recently, later I will discuss about the Roxborough case. I feel I know what is conditional there, but it's hard to explain when I explain this unjust factor to my students. And I find probably the possibilities you summarized in your book is very useful for me to explain this unjust factor to my students. And second implication is about whether there is a contradiction between restitution and the law of contract. If we ask the one who received the benefits under a valid contract to return, and this is also, again, a very difficult question that I find in the law of unjust enrichment. And I always feel a little bit difficult when I explain Roxborough case, the new Australian case, when you say, oh, yes, there is a valid underlying contract, but still we require restitution. I always find it difficult to explain why there is no contradiction, because intuitively, I feel there is a contradiction. And the third one is another fundamental question, that whether we need to terminate the contract first and then to require restitution. So these are the three questions that Jordan proposed, and find that, oh, my model can find an explanation for these three questions. And let me first turn to the first implication, first question. So what is conditional when we think about failure of condition? And Jordan proposed there are 5 possibilities. Probably it's because the person who makes the payment, his subjective intention is conditional, right? If that condition fails, then restitution should be granted. And this is the so-called thought bubble Alex just mentioned. I agree, it's something important. The subject intention is still matters, but I also agree with Jordan that this cannot be the possible explanation, because if I simply require you to return me something because I did not, in my mind, I did not want to give you the benefits, then I ask you to return. It's too subjective, right? It cannot be a possibility. And the other 2 possible suggestions or possible explanation for this, it's either it's the defendant's title or the defendant's entitlement to return the benefit is conditional. Then if the condition fails, we should require them to return. And in Jordan's chapter, you mentioned the third possibility, the entitlement to return, is something raised by Elise and James, right, in their book. And when I first started researching on unjust enrichment, I also read the book. And at that time, I feel there's no problem. I was convinced by then. And then I asked myself, when I was reading the Jordan's book, I asked myself, why at that time I had no doubt about their explanation. I think it's because my understanding, I come from a very civil law educated background. So my understanding of unjust enrichment is always affected by my previous understanding about the law of unjust enrichment without a legal basis approach. So at that time, I feel this is something, their explanation, Elise and James' explanation, it's something similar to their other proposal, which is there should be a lack of juristic ground, then we can grant restitution. I feel this too should be the same thing. So failure of condition, it means there's no legal basis or there's no juristic ground for the person to retain the benefit. And then I look at the 5 possibilities Jordan summarized. And when I look at the options, I go for the 5th one. So it means I choose the same one. But then I ask again, why I choose the 5th one, and why I feel, before I read the analysis, I already choose the 5th one. It's because I read your chapter 1 first. So I'm in that mindset setting already. And then I read your analysis about whether obligation can be an explanation, like what is conditional. It's the plaintiff's obligation to make the payment, that's conditional. I read that part actually twice because when I read it for the first time, I was convinced by your analysis. But then I read it again, and I saw that you mentioned obligation as just one ground, right? One juristic reasons. Then it means it's actually something in substance quite similar to James and Ellis' proposal. And in that sense, can we say, at least if we just look at the unjust factor value of condition, for that unjust factor, for this kind of unjust enrichment scenarios, then there's no substantial like differences between the absence of basis approach versus the unjust factors one, because as you said, it's the obligation which is conditional. Then obligation is just the one juristic reason. Then it means what matters is how to define what is a juristic reason here. And that's my question about the first implication. And about the second implication, I feel this one is extremely important, and I will definitely use your model next time when I explain the Roxborough case. And so for the Roxborough case, there is a valid contract between the plaintiff and the defendant. The plaintiff made the payment under the contract. For that part of money, it's supposed to be used for the defendant to pay a tax, tobacco license fee, but the tax later was declared as unconstitutional. So the plaintiff tried to get that part of money back, but the contract is valid. Then how to explain? You should grant restitution, but at the same time, the payment is made with a valid contract. That's the issue. And I think every time I touch this case, I just jumped to the conclusion. I say, oh, the conclusion is that even though there is a legal basis, the law, the court probably will still grant restitution. So then I end there. I don't go further to talk about this issue. But I think your model provides a quite beautiful and good explanation. It's simply because we don't just look at the contract per se, we look at what are the conditions for the person to make the payment under the contract. So the obligation should be the key part. But here I have another question, which I think is also the question for the whole model. That is, then how to determine which condition is that condition for a certain obligation, and how to determine that. As it like wholly depend on how we interpret, how we construe the contract. If that's the case, do we rely on the objective theory or subjective intention, or do we give too much discretion to the court to decide on that point? And the third implication is about termination of contract, whether it's necessary and also whether it's sufficient for the party to ask to seek for restitution. So basically, if you transfer something under a contract, then if you want to get the things back, get the benefit back, then do we need to first terminate the contract? Or if you terminate the contract, can you always ask for restitution? That's the question. And I agree with Jordan's conclusion, which is it's neither sufficient nor necessary. So basically, these are two issues. However, I have another question in my mind, which is, I think probably it's a little bit beyond the scope of your book. That is, then, but what should we do after the termination? Do you think it's still within the realm of contract law, but the contract is already terminated, right? Or if from the unjust enrichment scholars, their perspective, of course, this should be within the territory of the law of unjust enrichment. So we simply use the law of unjust enrichment to deal with all the issues. If someone wants to seek something back, then we we apply the rules of unjust enrichment, and we look at the circumstances. And in that sense, probably, I think your model will still lay a foundation, right? Because then we need to look at what are the conditions for certain obligations, certain transfer of the benefits. So that will be all of my questions, and thanks again. Thanks a lot for your book and also for the discussion.
Thank you for the excellent summaries and commentaries. we have given them a brief to be as critical as they wish. And as you can see, they're all singing high praises about the book, which speaks volumes about the quality of the book. Now, Jordan, you have 10 minutes to reply, but feel free to say more. to spend
Okay,
more time.
all right, I've written a lot of things, so just first of all, thank you. Not only is it very nice of you to read the work and to comment and say nice things about it, but actually, in the very nerdy way that I hope you've all experienced at some point in your law careers or law studies, it gets me very excited. I'm like, when you were talking, I started getting itchy, ready to say stuff, and so what I'll do is I will pick up on some of the things that they mentioned and try and categorize them to some sort of coherent thought. But if anyone who's ever had me in tutorials knows, there'll be a long way before we get there, but we will get there, I promise. So what I'm actually going to start with, I think, is one of Alex's comments, because it actually picks up on a little aside that you might not have caught from David, where he said something about implicit versus implied conditions. And he sort of looked at me and gave me a wink and said, maybe we'll talk later. So I'm going to try and explain what that is. And I think it goes a little bit to this me siding with the godhead of contract, Lord Hoffman. So one of the first questions Alex said, well, why does he want to revive this old theory of frustration, right? This thing is like the classic textbook will just say, everyone agrees that frustration can't be explained as bad implied conditions, implied terms, and so on. And now, hopefully, if this book gets enough wide circulation, to say, everyone but one agrees that this can't be explained on this basis. So why reject it? Well, so why revive it? Well, the first reason is that some of it's just been rejected for really silly reasons. So that was the thing that shocked me when I went back and looked at these cases. The most common reason the implied theory of frustration is rejected is that it's said to be fictitious. And they say, how can the parties have provided for an event which neither party foresaw? And this comes back a little bit to the subjective versus objective point. Well, that would be an excellent answer to the implied condition theory to rejecting it, if the way we construed contracts depended upon what the parties subjectively thought or meant. But contract 101 is that is not what we care about. We care about what the parties objectively intended. In a way, it's why you notice Hoffman never really uses the word intention. Intention connotes a state of mind. He always talks about what did the parties mean? What did the agreement mean? So it got rejected for some really silly reasons. I'll come back to this implication construction point, but then I guess something I don't do in the book as much, admittedly, but I've since done sort of another piece where I do this, is that equally, you're very right to point out that it does come down to this fight between some people who think that the doctrine of frustration is a rule of law, a rule of justice, and there's lots of Lord Justice Ricks in a case called the Sea Angel, and a number of cases at first instance applying that decision of the Court of Appeal. Also, the doctrine of frustration is a doctrine of justice, and therefore it should not be applied where it would be against justice. Well, the opposite view of that is, of course, to say, which is, again, Hoffman, that when a court is called upon to construe an instrument, it has no power to improve that instrument that it's called upon to construe. So I come back from the sort of opposite end, which I don't do as much in the book, admittedly, but I've done enough other work, of saying, well, what on earth is justifying courts coming in and altering the parties' agreement? Why does justice not require, this is something that Jonathan Morgan at Cambridge is saying, why does justice not require that the parties keep their promise? So one of the reasons I want to revive this is because it links it back to the concept of agreement, and I can actually understand why this doctrine of frustration exists. And where this actually started to matter is in these things called hell or high water clauses. So you get this often in finance agreements where the parties promise to perform absolutely, this is the word of the clause, absolutely, unconditionally, irrespective of any contingency whatever. And so these are often contained in leases of leases of aircraft. Then COVID happened, your aircraft stuck in Oman, and the lessee of the aircraft tries to avoid paying the rent. They say, well, the contract's been frustrated, I can't use the aircraft. And now all the cases have uniformly said, no, contract's not frustrated. But there are a number of cases where the judges have said, but it might be on more serious facts that actually the contract is frustrated. And I want to say, no, if you promise to perform, absolutely, though the heavens may fall, well, ordinarily we don't promise like that. We have all these sort of implicit, explicit conditions. But if you do, you should be held to that. And you can't have a doctrine of frustration coming in to save you, because what's the justification for that? So that's, I think, putting me there. On this point, this Hoffman point, you're absolutely right that The moment you start thinking about implied conditions, saying it's all about construction, you get back to this Hoffman-Neuberger debate. Hoffman and Attorney General Belize and Belize Telecom, and Neuberger and Marks and Spencer and BNP Paribas. As a starting point, what shocked me is that another reason for the sort of silly rejection is that the implied term theory, implied condition theory gets rejected, but then it gets readopted under the so-called construction theory. So to say, as Lord Radcliffe does, that at some point our obligations run out, is to me just another way of saying that the party's obligations are not absolute, but conditional, right? Because if I've agreed to do something, there's only two options. Either I agree to do it no matter what, or I only agree to do it subject to certain circumstances. So to say that at some point it runs out, I think the construction theory is just the implied term theory or the implied condition theory by another name. Okay, it's 5 minutes, so I'll try and be even, but I'll just finish off this point. And Marcus Smith has recognized that in a case called Canary Wharf, which is a very interesting case of frustration you should look at. So how then do I get back to this issue about implied terms? So one criticism of my work would be that I'm saying it's all about the implicit conditions in the party's agreement, but nowhere do I talk about the officious bystander or it being so obvious it goes without saying. I don't actually really mention that. Aside from this one paragraph where I note that if you're reading this, you might actually notice this brings up a debate between Hoffman and Neuberger. So in the book, I make very clear, I do agree with Hoffman. I don't think Neuberger has any justification for if implication is something different from construction. I come back to the same point. What justifies you inserting terms into the party's agreement if not to understand what they meant? But you can put that to one side, because one way I think you can understand the implied condition view of frustration, so notice I'm not saying implied term view of frustration, is that it's not about inserting terms into the contract for which you would on the positive law, even in Hong Kong, have to satisfy these additional tests, but rather it's about understanding the implicit meaning of an express term. And this is something which we often do, where you have an express term, and the question is, what is the scope of that express term? How far does it extend? And that, I think, most courts would agree is a question of construction. So I say, if you want to agree with Neuberger, that's okay, you can do that. But you can get around it by saying this is about ascertaining the implied meaning of an express term. It's not inserting new terms into the agreement. So all that's to say, I think that probably is my response to that point. I'll come back to something David said about these two cases, but I wanted to answer C's questions. So if an obligation, so the general thesis I have is that where you've got contracts, either I pay money pursuant to a contract and I don't get the counter-performance. Now, either the case was that their counter-performance was a condition precedent to my obligation to pay, in which case when I paid the money, I paid pursuant to an apparent duty to do so. But as it turns out, because the condition precedent wasn't satisfied, it didn't exist. More controversially, I say actually even advance payments are often subject to a condition subsequent, extinguishing the duty to pay if I don't get the agreed exchange for reasons that aren't due to my own fault. And so there it does it operates to sort of destroy the duty, which I argue is what justified the obligation in the first place. And that does create a localized absence of basis. So I am signing up to a version of an absence of basis model in this. We can talk another time about whether I sign up to it elsewhere. But I think that essentially is an absence of basis model, which is why I then have to say there's other juristic reasons which might also gifts, court orders, statutes and things, which can also provide a good reason for you to make some sort of payment. But equally, if those things are qualified or for some reason they're invalid, like in, well, Roxburgh's the obligation, but if for some reason they're invalid, that also creates an absence of basis. So yes, I'm signing up to that. Then I think you said how do we determine which condition is relevant to the conditions for the contract? I think hopefully I say somewhere in the book, but it's hard to know. I say something like this is not a panacea for the difficult issues of construction. I think I said in the frustration chapter, but I think that's true of restitution too, in that this is going to be a question of the construction of the agreement, and reasonable minds can differ. So in Roxburgh itself, where you've got payment being made by purchase price for cigarettes, purchase price, and then you've got a separate amount for this tax, which turns out to be constitutionally invalid. And the argument I'm saying is, well, you can understand that because the obligation to pay that proportion of the purchase price was conditional upon the tax being valid. And because it wasn't, you paid pursuant to an apparent obligation that didn't exist. The majority place great weight on the fact that these are separated out in the contract. And that's their reason for saying, well, you can see these as separate things. you could take the view that that was just done for accounting reasons, right? That there was one single obligation to pay the purchase price, in which case you're with Kirby and dissenting and saying actually the case is wrongly decided. So I don't think it removes these difficult questions of construction. And then you ask the third question is it, this model, is it a question of contract or restitution, whether you get your money back? And I think the question is, it's going to depend upon the basis upon which you're trying to get your money back. There are some cases that have been explained. There's one called Dyes and British Mining International Corp or something, where the judge does explain it on the basis there's an implied term in this contract that if you don't get the goods, they have to return the money. Now, I don't think that can explain all contracts, hence why I think often it's going to be this localized absence of basis model. But there's no reason to suppose that you can't have contracts where that is an express or implied term. So an obligation to return goods that you received if you don't pay the purchase price within 30 days. I think that you could explain, you wouldn't need to get the restitution. You just say the contract implicitly says you have to give the goods back. And that's an obligation you've got. Can I just say one very quick thing about Allianz Australia? Because they will not be happy if I don't mention the Australian case. So part of my model is that you can waive conditions, and that's a core part of the model. One of the questions is, well, when will that waiver be held to be final? And under the old law, we sort of had a position where sometimes it was final because of reasons of finality, and sometimes it was final because of reasons of estoppel that have been detrimental reliance. Today, because of this shift in understanding and forgetting about conditions, there has been an assumption that that principle of finality only ever applies to the power to terminate. And these insurance cases really bring out the stark contrast where you have a condition to the insurer's obligation to pay that you've disclosed all the relevant things. And Allianz was dealing with, very relevant to what we just experienced, was dealing with Cyclone Debbie in North Australia. So as I've learned, America, it's hurricanes, here it's typhoons, Australia, it's cyclones, but all the same phenomenon, just different seas they're forming over. And the insured hadn't disclosed some relevant thing, which gave, simplifying slightly, which was a condition of the insurer's obligation to pay out. And they said, no worries, we'll pay. Now, as David mentioned, the High Court split about whether or not that should be final or not. The majority said no. In this context, it's pretty much only where there's detrimental reliance. My question is simply this: it's a really difficult issue, but unless you see this distinction, you can't start grappling with the question about when it should be finality and when it should be estoppel. And courts just aren't asking the question because they're assuming that where you have true conditions, it's only estoppel and everything else is finality. But there's a possibility of both. Apologies for running.
Perfect. Thank you so much. Well, the summaries and critiques were great, and the replies were even better. Thank you very much for the treat. We have a bit of time for questions.